Law enforcement officials are taking...
For almost 15 years now, the United States has operated within the confines of the USA Patriot Act. Many students today, from elementary school all the way through college, have no recollection of a time before its creation. There was no TSA, there was no jokes about the government reading your emails, and the biggest looming terrorist threat was the Y2K bug. But for the entire country, that all changed on October 21st, just more than a month after the now infamous 9/11 attacks. The act itself was signed off as a declaration of war, not against a country and not outright against a specific people, but rather against terrorism as a whole. At the time of its creation, the whole country was nervously awaiting the government's retaliation to the terrorism that had occurred almost a month before, and most were willing to accept almost anything if it guaranteed their safety. Finally, their wish was granted. However, the repercussions that ensued were nothing short of devastating. For the first few years following its establishment, the act laid relatively under the radar. There were of course those from day one who saw the true possibility of what the act would mean for the future, and many called for the people to retaliate against what was occurring. They saw the signs, and they called attention to what changes had occurred within just days of its establishment. At one point, the Attorney General had begun to announce a tally during the weekly address, telling the public of how many people living in the U.S. on visas or seeking asylum they had arrested for suspicion of terrorist acts. However, once the number hit well over 1,200 and all those arrested had been Muslim, and they had yet to prove any correlation, the announcements ceased. A report later released by the Department of Investigations confirmed that this number had hit well over 7,500. These men and women that had been arrested all of course fit the stereotypical look that the FBI and CIA were on the hunt for. Almost all had somewhat lengthy beards and regularly visited mosques, which, oddly enough, didn't even fit the profile of the terrorists. Those that had committed the acts had intentionally shaved their beards and avoided places of worship for months, as to not draw attention to themselves. However, the worst was yet to come for many of those who were arrested. All were kidnapped in the middle of the night, and many had no idea that they were even being taken by the government until they were brought to the containment facilities. From there, one of three things usually occurred. The first, and best case scenario, was one where they found to have no connection, and, after weeks of observation, the victims were released back into their normal lives. The second, and more common option, involved those who were arrested being outright deported. They would be packed by the hundreds on commercial airliners being rented by the government and sent back to whatever country they were seeking asylum from. In many cases, this meant entire families going back to countries where they truly no longer had a home. No one is really sure what happened to all those who returned to the countries from which they were seeking shelter. The last, and by far worst option, was of course the now infamous Guantanamo Bay. Those sent there faced a fate worse than any other. The U.S. directly and explicitly denied them any rights. They stated that, as they were not on U.S. soil, they could not be granted any constitutional rights, and as they were not engaged in an active war, they were not protected by the Geneva Convention. Those sent here were kept for years on end with limited to no contact to the outside world. And the contact they had, they described their conditions as being similar to being kept in solitary confinement for upwards of 22 hours a day. Additionally, there has been multiple allegations of the U.S. committing war crimes against those who were imprisoned. However, America stands that those who went to jail in this area were in fact not protected by the Geneva Convention. There remained only one real instance where any intel was gathered as to what happened in the prison after its sudden influx of inmates. After months of negotiation, a BBC reporter was allowed into the outskirts of the prison with nothing but an audio recorder. What is revealed in under a minute of audio provides a stronger testimony to the conditions than a summary or a letter ever could.
Their families. We're just a few feet away, the other side of the wire, and one of them then spoke to all of us in English.
Are you journalists or what? Yes, can we talk to you? BBC television. We're from BBC TV. Thank you very much. After a long time we're looking you here. You need to Sorry? After a long time we're looking you here. It's amazing for us strange. We should saw you before, but we're looking now. If you don't move, you're going to have to leave. Please call around. back. Let's go. Tour's over. Keep it walking. Detainee. And we asked you as you started to.
The largest consequence of the act many had been concerned with was of course the prosecution of the Muslims. However, this quickly came to encompass the entire American public. Anyone living in the US could be investigated in any way the government saw fit using the act, without ever having to prove any evidence that the person in mind was anyone but a law-abiding citizen. One part of the act that was thankfully abolished in 2006 was called Sneak Peek. This part allowed for any intelligence agency to obtain what was essentially a secret warrant. This meant they could receive permission to investigate someone's property and look for what they felt was evidence to prove that the person in mind was related to terrorist acts. The catch was they never had to reveal that they had acted on such a warrant. Thus, many people had their property go missing or saw it moved while they were at work in what they assumed was a break-in, but in reality was the actions of government agents. However, there was another war occurring on the information front, and it was one being waged on every citizen, no matter their race, gender, or religious beliefs. The government was able to request large amounts of information from libraries, such as book requests and checkouts, along with as much personal information as the library could provide about each of the individuals who checked out said books. As an act of protest, many libraries began to shred entire binders worth of checkout information. Additionally, many littered their libraries with signs warning that should the government request it, the librarians would be required to turn over a sheet which showed which books individuals had checked out. However, more concerning and under the radar was the national security letters. These letters essentially allowed the government to request all information they felt important from places like internet service providers, including full names, email histories, billing information, and search histories of thousands of people at a time. Additionally, the letter came with an order that prohibited its recipient from ever mentioning the receipt of such a letter on the threat of being tried as a traitor. One case eventually came about to challenge this: Doe versus Holder. Doe stood for John Doe, who was represented by the American Civil Liberties Union. Throughout the case, the man being defended by the ACLU was forced to never reveal himself in order to remain safely anonymous. On the other end was Holder, who represented all government intelligence agencies, but specifically the FBI, the organization which Doe had received the letter from. The ACLU filed charges describing how such a letter was a violation of the First, Fourth, and Fifth Amendments, these being the freedom of speech, freedom of security in your own home, and a right to a fair trial. Initially, the ACLU saw a victory. Judge of the New York District Court, Victor Marrero, agreed with the prosecution and sentenced that the letters were unconstitutional and the gag order issued against Doe was to be dropped immediately. For 2 more years, the proposition sat in Senate, while they made appeals, many times sending the act back, insisting that small edits be made as to what exactly could be requested, deeming that this would be plenty. While most of these were minuscule and never made it into law, they did manage to pass that the gag order issued should carry more power, and those who receive it be silent about its collection for at least 10 years. Finally, in 2006, the Senate made a final appeal of the District Court's decision, in which they stated that nothing should be changed but a stricter gag penalty for John Doe. Thus, the ACLU and government were set into a 4-year-long legal battle, which eventually, unfortunately, served no purpose. When the case did finally come to an end in late 2010, the letters were ruled, despite their clear unconstitutionality, to still be completely intact, with one small addition being made. For the future, should someone receive one of the letters, they were allowed to talk to a single person about what that letter meant, that being an attorney. Additionally, the FBI was ordered to reveal an attachment to the order which showed exactly which information had been requested. The last piece of the case fell into place in 2014, when John Doe could finally reveal himself as he truly was: Nicholas Morrell, the owner of Calyx Institute, an internet service provider for the New York area. It was the length and decision of this case that finally served to bring the act to the public attention it so desperately needed. As more people read about it, the outrage spread. This was no longer a case where a small percentage of the population was being prosecuted, but rather, the government was gathering any amount of information on everyone. Quickly, news outlets sprang on the case, and what they hoped would be an increase of public awareness. However, mere months after the case, the news fell to the wayside. People became complacent with the fact that they could do nothing to fight it, and simply accepted it as part of their life. It was through behavior such as this that people became devastatingly uninformed as to what it means for any and all US citizens. And, most concerningly, those who use technology with which it applies know the least about it, those of course being Generation Y teenagers. In a recent survey conducted at Castle View High School, it was revealed that, while about 55% of students had at some point heard of the act, less than 15% had any idea of what it actually meant, much less what it could mean specifically for them. This concern has led to varying degrees of questions, not the least of which of course being as to what exactly this act entails. The act itself includes 10 titles and was renewed twice recently, including a renewal of part of it in 2011 and another part in 2015. While this would mean it expires in 2019, it is very unlikely that the next administration would not renew it, and even if they didn't, there would likely be another act proposed that almost mirrored it. These titles are extremely expansive and include an almost dizzying array of information, some of which can worryingly be argued to not pertain to terrorism at all. The titles themselves, for the most part, do not vary much in ways of intent, but solely in what capabilities they grant. The first and fourth title paired together were responsible for the creation of the TSA and border control that America has come to know today. This was established by grants for already existing border security programs exceeding $150 million. The second, fifth, and seventh titles all strengthen the intelligence agencies by adding more capabilities to the programs such as the NSA or CIA with the intent of countering terrorism. These include things such as national security letters, providing trade sanctions on countries like North Korea, adding data collection capabilities, and again, granting significant funds to each of these programs. This should also be noted for granting these agencies the ability to do what they feel necessary to collect intelligence on both inside and outside of the United States. The 8th, 9th, and 10th titles provide funding exceeding $5 million for training of police in the Middle East, as well as widening the terms of terrorist to involve anyone who poses a threat to a government official or civilians. It also speeds up intelligence agency processes, such as translation, so that America can get boots on the ground quicker when action is desperately needed, while additionally allowing for the arrest of anyone traveling internationally with more than $10,000. The third and sixth titles are where there seems to just be random pieces added in. The third title allows the government to intervene and prevent bank mergers from going through if they deem one of the banks or bank holding companies bad at preventing money laundering. And the sixth one speeds up the process for police officers' families to receive money if they are injured or killed in the line of duty. It later became evident that this last part had been tacked on as a resolution to existing cases, where families of police officers were having difficulty receiving funds, and it seems to further prove that the act itself has pieces inside of it that don't pertain to terrorism at all, which also hints that there's other parts of it that may have received opposition before but were hidden during a quick and welcome sign-off of anti-terrorism measures. Overall, there are several pieces of this document that certainly don't seem to pertain to terrorism, but more importantly, those that do seem to also be a direct infringement of the rights of US citizens. While these infringements do exist, it's in some ways easy to see why the country may have at first welcomed the act. Not only did it provide a much-needed sense of security for the entire population, but it also appeared to address the social problems that were arising in the wake of the attack. For a time after the attackers had been identified as Muslim extremists, there was a problem occurring everywhere, from coast to coast, where those suspected of being Muslim were targeted for brutal attacks. These were of course acts being opposed not by the government, but rather regular people on the streets. These included harassment of every variety, brutal beatings, as well as homes or stores being bombed with Molotov cocktails. There was even some cases where Muslims were outright murdered, as was the case with Balbir Singh Sodhi, who was fatally shot outside a gas station just 4 days after the attack. This was why the act was viewed as having potential for bringing a resolution, when in one of the lines of the act it was stated that to use the abilities granted by it, or any pre-existing abilities, to specifically target those who are Muslim would be unconstitutional. But the Guantanamo Bay cases, along with deportations, went on to reveal that such a statement held no real ground. An article from the New York Times went on to state that, quote, the law and its enforcement had an immediate impact on the lives of thousands of Muslim Americans and Muslim visa holders in the United States. In November 2001, guidelines for the voluntary interviews of more than 5,000 non-citizen men in the United States on non-migrant visas from either Arab or Muslim countries were issued to all U.S. attorneys and all law enforcement agencies. These guidelines encourage law enforcement officials to ask a series of questions meant out to draw the potential suspects linked to terrorism, including queries such as, how did you feel when you heard the news about the World Trade Center attacks? It was thought that such interviews might generate lead in the prosecution of terrorists. Men, ages 18 to 33, who had been living in the United States on student, work, or tourist visas since January 2000 were sent letters asking them to volunteer for questioning. Even though the interviews were said to be voluntary, there were implications that visas could be revoked if they failed to volunteer. These interviews were of course those that the Muslims who were arrested faced before they were either released, deported, or imprisoned. With this in mind, we are forced to venture forth and wonder, what may our country look like in the future, and what can we really do, if anything, to fight this?
Certainly, I think the technical right of the government to pass these things is established, and I think that they were able to establish many of these laws through legitimate authority, although I do believe that the questions like this are legitimate, and I do believe that that this what's legal or what's lawful is oftentimes maybe awful, right? In the sense that the justification that these laws were acceptable legally certainly by no means that they are acceptable morally or that what we ought to be doing as a country. I think it is distractory. And I think that that element means that I have a hard time making the argument that this is good. I think overall that it's important that we remember that all of these events and all of these things that took place were already crimes, and that we have laws already against heinous acts of murder and of violence and of destruction. And needing and requiring additional measures to accomplish what is already in place seems to be the excessive nature of some of these laws, that they are bringing in elements of quote-unquote justice that we already should be able to do. Retaliation, I think, is kind of the disconnect that I have with kind of the transpiring of these events. I think understandably people were hurt, and understandably people were kind of shocked. I think the wrong response to hurt, shock, pain, violence is kind of that knee-jerk reaction. Many of the laws that ended up being involved in the Patriot Act were pending legislation that many people felt did exceed the Constitution and did feel went too far, but were only passed in a moment of panic or in a moment of crisis or in a moment of, as you say, a desire for retribution.
The most important question, though, lies not in what we may have taken away, but what we may reclaim. It can be argued from courts, district to supreme, that this act lies nothing short of completely unconstitutional, and it's impossible to deny the stripping of multiple rights given to all U.S. citizens in the Constitution is anything but a civil rights violation. However, time and time again, though the court may rule in favor of the people, nothing comes of it. The act does not change, and the people are left to question why this may be. A short answer would be that the people in many of these cases have no real power. The bottom line is that, while the government may allow people to settle discrepancies with each other in court, it is nearly impossible to take the government as a whole to court and win. To do so would essentially require the intelligence agencies to state that they willingly surrender their power to use these abilities. This being because there is no real way to completely strip a government agency of its power, short of a Supreme Court ruling or executive order. However, seeing as the Supreme Court has already ruled to keep the act alive and kicking multiple times, and the act itself was a collaboration between multiple parts of the government, it is extremely doubtful that powers such as these will soon be taking their leave. This, of course, takes us to the root of our problem, which is, of course, how can we expect that submission of government powers while we simultaneously become less educated as to what they are and more complacent with our lives under them? This question is not one that has a black and white answer. We can of course expect that sometimes in the future, we will be faced with new issues involving this act, and the technology that surrounds it. Only recently, a case has surfaced involving Apple and the DEA. The case itself could actually hint at a future where progress may be made, as it appears as though the government has finally had some pushback which restricts their abilities. The DEA had demanded that Apple develop a software to allow them to access Apple phones to further their investigations. This had been in the making ever since Jun Feng was arrested and pled guilty to drug charges back in October of 2015. And, given the precedent set by many cases which preceded this, such as Doe versus Holder, it was expected that Apple would put up a valiant fight, but eventually have to submit to the government's authority. However, on March 1st of 2016, the whole country was pleasantly surprised. It was on this day that Judge James Orenstein of the Eastern District Court of New York ruled in favor of Apple. He ruled that there was no way for the FBI or DEA to, quote, justify imposing on Apple the obligation to assist the government's investigation against its will. This, for many, provides a glimmer of hope. Apple is by no means a small company, and for them, a win as court is far from a new concept. Thus, another victory for them is hardly groundbreaking. However, it is what this victory represents that truly has the ability to move mountains. For the time, it is truly unlikely that we'll begin to see smaller companies or individuals winning cases such as these against the government. However, this is certainly a step in the right direction, as it is establishing a new precedent that benefits not the government but instead its people. It may yet be decades before we truly see movement in the direction of restricting the abilities of the government to prosecute and investigate using tools such as the USA Patriot Act. And by no means does a victory such as this push our country into a space where we can truly say innocent people are safe from government observation. But changes can be made. As a people, we must persevere. We must become educated about the policies that will not only shape our lives, but the lives of the generations that will follow us. And we must draw the line before we find ourselves living in the land of the slightly less than free. We can make the change that will bring about a generation once again free from overbearing government confines. The future is grim as of now. To say that we know what to expect would be an outright lie. But for the time being, we can take what abilities we are presented with and use them to their fullest. Our knowledge of government policies and our ability to make a change can be wielded as what may be our last defense against what has quickly become a campaign against all American people. If we let this proceed any farther without giving even an ounce of effort to make a change, we will quickly find ourselves living in a no longer hypothetical nation of spies.